Audio Jungle.
Welcome to the third episode of Law Unscripted. This is Disha Bess, and today we're delighted to have with us Ms. Ankita Ray. She is a partner in the labor and employment practice at Cyril Amarchand Mangaldas and has over 15 years of experience on focusing on various employment matters. Ma'am, to begin with, could you please take us through your legal journey? What drew you to law as a career?
So like every other high schooler in my day and age, I think this generation is much more focused. It was a process of elimination for me. So I come from a family of doctors and engineers. But around when I was in class 11th and 12th, I figured that I do not want to take that path. What interested me was something a bit more fluid. So I did toy around with the idea of pursuing English, and at that time we were hearing a lot of good stuff about NLS, and the study of law came into focus, because traditionally there's nothing to do, we'll do law. That was the idea in our parents' generation, right? But this, during my time, there was a lot of how should I put it, talk about corporate law, right? About having like a proper pedigree when it comes to legal studies, which is how it came in my radar. And then of course talking to friends, family, this just turned out to be a good area where I would focus on a lot of different subjects, right? Which interested me.
So you just mentioned that choosing law was a practice of elimination for you. Did you move around other practice of laws, other areas of laws before choosing labor and employment per se?
So I would like to say, as dramatic as it sounds, that labor and employment chose me. But I started my career with doing PE and M&A work.
Okay.
At that time also the Information Technology Act, the data privacy rules, the sensitive personal data, those concepts had come in. So there was a lot of advisory on that front as well, which gave me some exposure to the advisory side of a law firm, and I quite enjoyed it, right? So now together with one kind of advisory, my scope expanded and I came in contact with labor and employment laws. And I just began to do more and more of it, and liked it. And then slowly in India, law firms started having particular practice teams dedicated to labor and employment, which is when I got into core labor and employment teams. Yeah.
So what are the aspects of labor and employment law that keep you engaged in your day-to-day work? What is it that you like about it?
So what I liked about it when I started doing it still continues to be the same.
Right.
Okay, which I think is a very important factor, because it means that my interest in the field has been kept alive. I think the best thing about this field of law is that it's very dynamic, and you're dealing with human beings and their reactions, right? So no 2 days are similar for me. Okay, so let's say you're talking about termination of an employment. Okay, I may react to the news in a way. You may not react to the news in the same way. It will be a different. And as lawyers, we need to see how to handle, that, keeping in mind the interest of the employer, ensuring that the employee is also treated fairly. So it's very dynamic. You may be dealing with the same subject matter, but in a different way every day. So I think that's what keeps me still loving this as a practice area.
Right. So you just mentioned that you deal with human beings, real human beings, when you practice labor law. How do you How do you stay objective in situations when there's an emotional weight in your work as regards to any matter?
That's an excellent question. And I think I've been able to do that because of a lot because of my seniors.
Right.
Because whenever these questions have come up, and they do come up, right? Sometimes there are um, moral conundrums,
Right, of course.
or when I was a young professional, you're still not used to a certain way of thinking, right? So at that time, what helped me the most was approaching my seniors and talking it out to ensure, so they had a better working of the corporate world, right? That why something was necessary, why a particular action was being taken. So to understand the background of it, I think helped me a lot, together with being able to voice out my concerns and to hear from seasoned professionals. I think that gave me a lot of calmness and peace to deal with matters, which I hope, that's why whenever there are juniors in my team, I always tell them that anytime you're facing any issue, or you have a gut feeling, or you're not feeling good about it, come up and talk, because labor laws is one subject where you can't just go by the book. There are a lot of other human nuances to it.
So has it been easy for you to leave emotional baggage at your workplace and then move forward to your personal space? Has it been an easy journey that way?
It's not easy. It's not easy, especially in the law firm framework. We are in a client-facing service industry, right? But the moment you look at it from the perspective that your clients need your assistance, you are their trusted advisor. There's something that will come from within to ensure that you do the best for them. And finding that balance, again, that I've been very lucky with the seniors I've worked with, even the current senior partner that I work with. I think dialogue always helps, and a lot of it is apportioning time. Okay, time management is a big facet of being a working professional, especially in our industry. It's a bit of hits and misses. You need to find your sweet spot, but it is doable. Like while I've always been a law firm, I'm currently dealing with a very active 1-year-old.
Right.
I have my own hobbies. It's difficult to find time, but it's not impossible. You just need to kind of power through, keep the interests of your clients in mind as well as yourself, and just make a few tweaks in your schedule, have constructive conversations. I'm big on having a dialogue. Talk it out, vent it out if required. You have no idea the number of times we as colleagues vent out to each other.
I didn't know
Because
that.
it's a high pressure job.
Of course.
Right?
Demanding job.
Yes, so to have that safe space is very important.
Right. Definitely having a safe space is very important. The next question would be, what does a typical day-to-day operation of yours look like in the firm? What kind of work do you do the most?
Again, by virtue of the nature of work I do, there's no fixed kind of step by step that I can tell you, and which is the beauty of the job, which is precisely why I like it. But I think the first thing I do and which has helped me a lot is kind of seeing what I need to do for the day. Okay, so to kind of make a list that these things need to be done. These are the deliverables for today. At my level, also apportioning work, right? So I think the planning of the work or planning of your day is very important, and I realized it probably a little later in life, but I think if I had done it when I was a young adult in general, as a student also, it would have helped me. Okay, so I think how you plan your day is very important, and that's one of the first things I do. Uh, I usually like to tackle the most difficult one, difficult deliverable first up. I would like I like to do my background reading. Um, for any, so if I know that today an opinion on a topic has to go out, the first thing I would do would be to kind of just skim through the law. Possibly I've read it many times, but just to skim through so that I'm prepared, and when I need to actually review the opinion, I already am prepped for that. And then I think work in a day, it includes reading up, discussions with not only your peers but also with your juniors, because it gives a new perspective. Again, a big part of my job is not only technical but also reputation specific, or there are softer sides to it, communications, etc. So to have again ideation, basically, where you sit with the team and you talk to them and you figure out what's the best way to do something, or if you have a different point of view, to have those discussions.
Right.
So all this happens during the course of the day.
You just mentioned that apportionment of work and discussions are a big part of your day-to-day work life. What is something that you've learned in that course, especially with junior lawyers who are younger, way younger? What is something that you've learned very recently, or maybe something which is worth speaking about junior lawyers and how you tackle them, how you work with them?
So junior lawyers, right now it would be what, Gen Z?
Yes,
Gen Z lawyers, right? Yes. And a lot is being said and spoken about them. What I really enjoy and is that they're not afraid to speak up.
Yes.
Okay, and that's something, as I've been dealing with them for a few years now. I think that's something that came as, frankly, as a shock also, because we were not
used to.
very used to it. Like, we would put it in a more mellow way.
Yes.
Whereas now it's very direct. Okay, but after that initial shock was over, I think most of us really appreciate it, because like I said, law in general is such a moving landscape, right? To get a fresh pair of eyes, to get a new thought, right? That's very important. And which is why I enjoy having conversations with the young lawyers, and you'll be surprised at how many of the good ideas come from them.
I think, as per what you were saying, having a discussion is very important, and then after that, being direct in those discussions, I think, to some extent, very important. On this note, we are moving forward to our next segment, which is area-based questions. On November 21, 2025, India saw perhaps the biggest overhaul of its labor laws. 29 central laws are now consolidated into 4 codes, namely the Wages Code, the Industrial Relations Code, the Social Security Code, and the Occupational Safety Health Code. Ma'am, although the labor codes were notified centrally, their implementation depends heavily on state rules because labor is a concurrent subject. And as of January 2026, only a few states have finalized their rules. Is there confusion that you see in your work? Is there compliance gap across multi-states operation especially?
So there has been this misconception that because the rules are not yet in place, compliance with the labor codes is not required. But that is not the case. It is indeed a misconception. Because if you see the 29 legislations, those have been subsumed and repealed, right? So the labor codes are very much in force. Now, what has not been repealed and what still continues to hold fort are the rules under the erstwhile legislations, are all the orders and notifications issued under the erstwhile legislations. So the legal landscape as we speak today is, wherever the labor codes are not dependent on rules, they are applicable from November 21st, right? If they are dependent on rules, then if there are rules under the erstwhile legislations, that will be your compliance and your legal framework. Right? The only aspects which there is a gap till the rules come up are in relation to the newer concepts. For example, say your workers' reskilling fund, right? So earlier, for the term used was workman, right? There's a similar term here, worker, with some changes in threshold for supervisory workers. If you were terminating their employment after they completed 240 days of service, you had to give a retrenchment compensation. Now, in addition to that, you are also required to contribute 15 days of their salary into the worker reskilling fund. Now, this is a new concept. So, the earlier rules or the rules under the erstwhile acts also don't talk about it. Right? We will have to wait for new rules to come up to see how this will play out, because the fund has not yet been created. So only those aspects are the ones that are still in a limbo. Otherwise, the labor codes are very much effective.
Ma'am, talking about the workers' reskilling fund, there is no directions as to the utilization of that fund, no oversight mechanism on that utilization as such. Do you think the rules will cover that, or is it just a gap that we have?
We are expecting that the rules will cover that, and there is an indication that in the codes itself, if you see what the fund has been defined as, that it will be used to develop the skills. Of course, how it will be utilized, in what ways, how the employees or the workers can take benefit of it, we are expecting all of that to be covered in the rules.
Okay. In this transitional phase, how is your firm assisting clients, especially not just in the technical legal sense, but also how are you complacing them? Because there must be a lot of anxiety as to what is going to happen next, because so suddenly a lot of laws have changed. So how is that panning out?
True, and the industry has been in a bit of a quandary as such. In fact, our phones are constantly ringing from November 21st. We've been doing meetings and client sessions. I think on an average we are doing a couple to three every day. At our firm at Cyril Amarchand Mangaldas, our team, we've done a road show across all our offices across India, where we've invited clients and spoken about the labor codes. Our advice to the clients, and if anybody is listening in as well, is do your groundwork very well. So see how the labor codes are affecting you. Understand which of the facets are applicable to you right now. Okay, for example, wages, right? It's not dependent on any of the rules. So get going on analyzing your wage structure. For anything else, be in a ready state so that whenever the rules come, etc., you can immediately go ahead and implement. But at the same time, we are giving comfort to clients and requesting them not to have any kind of a knee-jerk reaction.
Yes, of course.
For example, we are getting queries that, okay, so and so person is leaving. How do I make the payments, and should I do some recalculation, etc., etc.
Yes.
So our only thing is that whatever you do now will be setting a precedent for your company going forward. So be very careful, take your time, absorb what the risk is, and start preparing. Right? So we are doing a lot of, say, wage structure analysis. We are doing a lot of matters where it involves analysis or recognizing whether the workforce are employees or workers, because a lot of the benefits under the codes are applicable only to workers. So internally you need to know what your workforce consists of. So these are two things we are doing right now, because these are applicable.
Okay.
Also on, say, leave. There have been some big ticket changes in the leave policy. So to see what the current leave structure looks like vis-a-vis the applicable law, what exactly is applicable. Tomorrow, if we are talking encashment, what will be the exposure, the financial exposure for the client. So these are some of the big ticket discussion points that's happening in the industry right now that we are helping with.
Ma'am, we were talking about the definition of employee and workers in the new codes and how it has been changed. But the code has recently also recognized gig workers as well, but they have not been classified as employees at all. Nor does the code integrate them fully into traditional benefits such as EPF or ESI. Do you see this as an incomplete reform as of now?
No, I wouldn't say that it's an incomplete reform, because the idea, yes, gig and platform are not the regular employer-employee relationship. That's something that they don't have.
Yes.
But the idea definitely is to provide them with certain benefits, including like Provident Fund, ESI. We have to wait to see the schemes for gig and platform workers come out, because we are very confident that that's where they will cover the exact benefits. In fact, if you see the codes, aggregators are required to make certain payments in relation to the platform workers, a certain percentage of their turnover, etc., for the benefit of this group of personnel. So I would not say it's an incomplete reform. We just have to wait for the particular schemes to come out for this group of the workforce.
So, moving forward to the next question. Talking about the wages under the code, the definition has changed substantially, and there is a new 50% proviso rule in the definition of wages. How has it impacted the CTC structuring in various cases, and have employers substantially redesigned their salary structures for this purpose?
So it's important to understand why the definition of wages has been specifically brought into effect, right? Under the erstwhile legislations, you pick up the EPF Act, ESI Act, Payment of wages was defined differently, right, across the different legislations, which meant that it was administratively very cumbersome.
Yes.
To make it easier, therefore, now we have one single definition of wages. So all your employment benefits, be it your PF, your gratuity, ESI, everything now has to be calculated on this specific definition of wages. Right? Now, what companies need to see, what employers need to see, is what, given their current CTC structure or given their current salary structure, what will end up being wages on which these benefits will have to be calculated. So companies are right now doing two things. One is to undertake this analysis to see what exactly falls within the realm of wages, and keeping that in mind, to see if they can restructure their wages in a more functional manner. So these are the two exercises that the industry is doing right now, which may end up in a revised wage structure for their employees.
Right. So taking this tangent forward, the new definition of wages, I think the wage base for calculation of benefits such as gratuity has increased now. Do you think, ma'am, the tax exemption limit that we have for private sector employees, which is at 20 lakhs, I think right now, and for central government employees, it's 25 lakhs. Should that as well be increased?
So see, for gratuity, actually, that's a misconception. Okay. The law was always telling employers to calculate it on basic plus plus. It is the industry practice where you needed to calculate it on basic. But if you see case laws, there is, say, the TI cycles case, then you need to read it together with certain case laws under the Provident Fund Act, which is your Vivekananda judgment, your bridge roof judgment, all of that put together. Gratuity also, similar to PF, had to be calculated not only on basic but also other allowances which followed the UNO principle, which is basically any amounts that were universally, necessarily and ordinarily paid across the board to employees or a class of employees. Yes. So the law for gratuity, if you see, it actually has not changed. It's just that it has been very clearly codified.
Now, ma'am, the OSH code has now also introduced various changes such as web-based inspections or electronic registers for that matter. The question here would be that could this create an operational disadvantages in certain rural areas, establishments there, because of no access to such digitalization, as we say?
We'll have to see how that plays out, because at the end of the day, I would think that if due to infrastructure issues you can't maintain it online, it's not that an offline maintenance of registers won't be taken into account. I'm also drawing this from the fact that if you see the labor codes, the entire tenor of the labor codes have moved from that of penalty to facilitation, right? The inspectors are now called facilitators cum inspectors. So my idea would be, my sense would be that once you give the inspectors a reason as to why maybe an electronic document is not possible for you to maintain, then some kind of facilitation process would occur in that case. Having said that, this also kind of gives us a reality check, right? When as a country we are moving into the digitization era, it is only in our interest that the digitization process percolates across the country and across both urban and rural areas.
Are there any specific areas other than registers and compliances that you think could be digitalized in that sense, or maybe could use some ma'am, there are a lot of increased compliances that we see in the new codes, and especially financial. So could this in any sense lead to a reduced hiring or maybe unemployment at some stage?
See, if there's a demand, right, there will always be hiring, and there is a demand. And I would say that yes, maybe there is a cost implication of the labor codes, but in a lot of cases this will just be a one-time cost. It is also an opportunity to set the house right. Now we have, to a great extent, the law particularly sets out what is required to be done. It also provides that where there's any kind of ambiguity, some kind of facilitation process will occur. Of course, we'll have to see how it plays out on the ground. But I would think that this will only help in creating a better industrial relation between the employers and the employees.
Touching the OSH code tangent again here, ma'am, the Shops and Establishment Act also have governed employee working conditions such as leave, working time, overtime, etc. for a long time. But now we see that the OSH code also has terms on leave, working hours, overtime, etc. What is your take on this overlap? Do you see this as a conflict between the two laws?
There definitely is a conflict between the two laws, which is when we have to go back to the labor codes, right? There are two very interesting sections. One which says that in case of any conflict, it is the labor codes that will supersede. But it also says that in case of conflict, whichever is more beneficial or whichever interpretation is more beneficial, that will prevail, right? Net, that brings us to the inference that if there are two legislations on the same subject matter, for example, like you rightly said, leave, we'll then need to cover what the OSH code says and what the state specific shops and establishment says, and see which one is more beneficial or which combination between these two laws is more beneficial, and then map it to the policy of the company. In fact, this is one extensive exercise that companies are doing, that I'm also helping my clients do as we speak. Because remember, now under the labor codes, there is also the concept of year-on-year encashment for workers, right? So there may be outflow for the company. So it is very important for them to map their leave structure and their leave policy. There is also another nuance, as if this was not complicated already, is that if you see the shops and establishments legislation, they are applicable to a wider group of people. Typically only your top management will be excluded. So it applies, if we see in the terms of the labor codes, it will apply to workers and employees.
Okay.
But the OSH code applies only to workers. So then what should your leave policy be? Because administratively it will be difficult to have two different leave policies, right? Then again, if you have presence in more than one state, the Shops Act differs from each state. So how do you kind of balance out all these things to ensure that operationally your business runs fine? It's a very interesting facet. Yes, it is very complex, but it is something that employers would need to figure out sooner than later, and we are seeing a lot of our clients doing the groundwork on this.
That's a very interesting nuance, honestly. Coming to Karnataka now, specifically. Recently, Karnataka has introduced a menstrual leave policy for various establishments, but there are no clear specified penalties for non-compliance here. And implementation also remains fragmented across states in case of a menstrual leave policy. Ma'am, do you think the labor codes have missed the opportunity to unify this rule of menstrual policy? And particularly, it could have been included in the OSH framework. So what do you think about that?
Yes, it could have been. It could have been. It would have made it simpler for employers as well, right? Because now we'll have to map what other states are doing. If you are an employer with operations in more than one state, how to go about this. So definitely, I agree, it would have been more seamless if this were included in the labor codes. But see, again, the menstrual leave that was introduced in Karnataka, again, that's sub judice right now, right? Because I think a PIL is still pending, and the High Court gave some interim order, then again revoked that. So at this point, we don't know even in Karnataka how this will exactly play out. So it's more of a wait and see approach.
Ma'am, in your practical experience, could you share some sort of complex issue that companies are struggling with the most during this regime?
Under the labor codes?
Yes, the new codes.
I think the entire gamut of it, frankly. Because this will have, this is the first time we are seeing, legal teams, HR teams, as well as the finance teams being involved. Because it has a ramification for everyone, right? All these teams are coming together to see how this will play out. But like I said, I think the two main things that companies are looking at right now is your wage analysis and getting that right, and your worker versus employee definition, that distinction, and again to get that right, they are mapping the leave aspect, because again that will have, apart from there being a possible monetary outflow, it will also impact employees specifically, right? So how, not only about how to change the leave policy, but also how do you communicate things to employees. All of this is coming into the picture, and we are seeing a lot of activity, especially because the financial year end is coming up. But I would say these are the three big ticket items. The other one, yes, that's also a very critical item that employers are looking at, is contract labor.
Oh, yes.
Okay, because now you can't use contract labor in core activities, but again, there are certain exceptions where you can fall within those exemptions. So, and again, remember, contract labor can actually hamper your operations, right? If tomorrow you're not able to use them, your entire factory operations, for example, can come to a standstill. So that's also something that employers, I wouldn't say struggling with, because I would like to think we as law firms are there to help them. But yeah, that's something that they are definitely looking into.
Coming up, okay. Ma'am, specifically in acquisition cases, there are a lot of employees and sometimes hundreds of contract workers as well. What are the top labor risks that acquirers often underestimate during this process that you see?
So it's far simpler in a share acquisition because nothing is changing. Only the shareholding is undergoing change. But when there's say an asset sale where employees are moving, or even a slump sale where there's a transfer of an undertaking, that their employees and how you treat them becomes critical. Because under law, if it is a transfer of an undertaking, you are required to give them continuity of service for benefits, and also your benefits have to be no less favorable in aggregate, right? Now, again, this is a law, so we need to do a slightly deeper dive to see what are the benefits that they are entitled to right now. What will they be entitled to once they transfer? If we are not matching apples for apples, because that's not the intent of the law, it should at least be apples to oranges.
Right.
So that entire benefit structure we've seen sometimes, not being picked up at a slightly later point in time, which could potentially create problems. Because not only does that have ramification on the actual benefits, right, and the cost assigned to those benefits, but also if you're changing any of the benefits, how will the employees react? How to encourage them to move to the other, to the new employer? So all of these things have to be clearly thought through.
Right.
So it's a mix of the technical aspects, right, so that you're ticking against the law. It is also the operational aspect. If you're moving any benefits, how do you move it? If it's say by way of a trust deed, then does the new employer also have a trust? Can we do from a transfer from a trust to a trust? So those operational aspects. And third would be how the employees would react, right? So while I've mostly at least seen companies pick up the actual benefits part, but the operational and the human side of it sometimes is neglected till the last minute.
That is really insightful. Ma'am, in the past few months, what has been the single most common question your clients have been asking you regarding the new codes?
The most common question is whether it's applicable right now or not.
Okay, right.
Yeah, and also I think that questions like, do I need to pay PF on the new definition of wages or not? Because PF, there was a bit of confusion. It seemed like the EPF Act itself would continue to be applicable till November 21st, 2026, right? Because the schemes and all, there's a holiday period for PF for 1 year. But now I think January or early February, a corrigendum was issued by the government to say that the EPF Act also has been repealed. Okay, which means that while there is a holiday period and everything will continue as is under the scheme, because till November 21st, 2026, the calculation itself will have to be made on the new definition of wages.
Right.
So there was a lot of confusion in this regard as well.
Okay, okay. Ma'am, do you remember your first high stake employment negotiation that you handled, and what were your takeaways from that?
I do actually, because we were negotiating again for a transfer of an undertaking where a sizable number of employees were moving. So we were all in this big boardroom with uh, our clients and the counterparty and their lawyers and everything. And I must have been in the first year of my profession.
Okay.
So there was a lot of anxiety, especially seeing a room full of people. Um, Also, many of them quite senior to you, and I think the anxiety started even before I entered the meeting, because you think it'll be like the show on TV, right?
So
Or on
especially-
Netflix. Now that it'll be there will be a lot of aggression, a lot of adrenaline and everything,
Right, right, right.
and that we will essentially be fighting with the other party, like verbally
Yes.
quarreling it out. And I was very surprised to see that it's nothing like that. And I think over the years, that's what I've learned from my seniors at the firm, to handle situations not with aggression, but to arrive at a solution, and to treat the situation with grace. Okay, to give the other person the comfort that, listen, we are not here to cheat you out of anything. We are looking out for our clients, and also to come at a level playing field. That's our goal. And there were no egos as such involved. We were just looking after the interests and to actually get the deal done. And it so happened that by the end of it, the counterparty also was so appreciative and was so friendly with us, right? So that was a complete reset for me, that aggression is not what is required. What is required is to approach everything with a solution oriented. You need to look at it to arrive at a solution, and you need to treat everybody with respect. A loud voice or saying X number of words per minute does not cut it. You can talk less, you can talk in a low volume, but you need to make sense, and you need to appeal to the interests, the collective interests of everybody in the room. So I think I'm glad that I had that experience right at the beginning of my career, because it kind of set the path for me going forward.
Right. So even as a law student, sometimes when I watch lawyer dramas, especially Suits for that matter, it's a lot of aggression that I see. Two lawyers would be fighting over something which is very simple actually. But have you ever also felt that in your young times, when you were younger, that being a lawyer is like that, being aggressive most of the times, or saying what you need to say and stuff like that?
Of course, I think we've all gone through it. Okay, which is why I said I'm lucky that I had that experience at the beginning of my career. And now, after many years in the profession, I get where we young lawyers were coming from, and where maybe even you young lawyers are coming from, because you need to do well in life, you need to get that job.
Right.
There's a lot of competition and everything, so I completely get it. But since there will be, I'm hoping, a lot of young listeners to this, I just want to give them that comfort, that your voice need not be the loudest in the room. Be very confident of who you are. Be very confident of your take on the law.
Right.
And that should do it. And also, don't kind of give in to any kind of aggression. You don't necessarily need to take it. Everyone has their own way of dealing with it, but don't get overwhelmed by the aggression, as long as you are confident about your knowledge and your thoughts.
That's a very warm piece of advice, I would say. Ma'am, coming forward to the next question. When we talk about posh cases, they are often a concern of reputation as much as the concern law. So, how do you manage perception of people in that case, and how important is it?
It is extremely important. In fact, not only posh, but every other facet of labor and employment laws, like we were discussing,
Yes.
right? It deals with human beings. So perception is very important. Posh, of course, there's a reputation aspect for the client organization. Um, but it's very heartening to see, and we also recommend that don't look at it from the perspective of maintaining the company's reputation. Do what is right. And I've seen employers as well, and there has been a shift where employers want to do the right,
The right
thing, right? And to follow due process. And whenever these matters happen, our advice is not only what the law is or what the law says, but a lot of it, again, that's a part of being a labor employment lawyer, a lot on the strategy to be adopted in dealing with that matter, right? Because a matter can be dealt with in different ways, right? How best to deal with it. We also work with, in high profile matters, we work with the PR teams of the companies to how it should go out there. But the bedrock of all this, any kind of communication, any kind of reputation risk, is ultimately to ensure that the confidentiality of the parties, especially of the complainant, is maintained, and due dignity is, always maintained. So that forms the bedrock of any action that we recommend our clients to undertake.
I would like to ask you another question on the boardroom answer that you gave. So, when advising multinational boards of work, for example, workforce reduction and matters like that, how different is the conversation at the boardroom table as compared to the actual floor of that actual establishment?
So see, one is who are you talking to even in the boardroom, right? If you're talking to foreign clients, for example, you need to kind of explain to them
Oh, yes.
how the Indian, you need to simplify it for them. You need to explain the concepts that can be new to them. So, say we deal with clients from various, say, European countries, from Australia, from the Americas. Uh, Particularly when it comes to the Americas, their labor laws are very different from ours. So, how to kind of give them the Indian context, but at the same time not overwhelm them, right? Even if it means quickly reading through what the law of that other country is. Now information is so easily accessible, so that you can draw parallel and say, in US you have hire and fire, you can fire without notice. In India you cannot unless it's for a proven misconduct. Now, what happens on the floor for that, we again depend on the HR and the industrial relations folks. Because, see, it's one thing to have everything on paper, right? But at the end of the day, and again, that's something we always tell our clients, that when the authorities look into it, they will look not only at your documentation but also the actual practices, right? So there needs to be alignment, and if we see that the practices are something that creates a certain risk, then we highlight that and we see how to kind of fix it or kind of re-strategize. So there, our work does not stop by just saying, "Acha, this is the legal advice." Okay, we need to have those discussions to see how in practice are you operating, and then decide the final steps to be taken.
Okay. Ma'am, labor and employment law, like even your answers right now, they sound very policy heavy and strategic planning and all of that. But what is one unglamorous part of labor and employment practice that young lawyers often do not see?
I don't think it's very policy heavy, but I get what you mean, that there are very specific laws for
Yes.
specific
Things.
situations. See, the unglamorous part would be, I think, the same for all legal practices. You need to read a lot. Okay, your background work has to be spot on. In fact, there are, at the beginning of a conversation, we were discussing, right, how my day is never similar because people react differently to the same news of termination of employment. But for each of these situations, there may be case laws, right? So you need to look for fact-specific case laws. So there's a lot of research involved. And there are also times where, you'll shut your book, you'll shut your laptop, and you'll just stare at the wall and think that, okay, what else am I missing? How else could the reactions happen? What else could happen? So there's a lot of work in the background that goes on, a lot of research at all levels. It's not only the juniors who are doing the research, all of us, lot of reading. But I think that's largely true for law as a profession in general.
So, is there any advice that you wish someone had given you when you were a junior lawyer or a law student for that matter?
I think I was blessed to have, when I joined the labor and employment practice at what was then Amarchand Mangaldas, I had a great boss. She's still my boss.
Okay, that's good.
Yeah, so I've been blessed to have received good advice and being handheld through, and that's a big blessing that I realize that not everybody gets. But like we were discussing offline, that you need not complicate your life by thinking, okay, networking is the most important aspect, or that let me do focus more on networking, that even if I don't do my study of law, I'll do it later. So you're getting the priorities right is very important, and the priority would be to develop your understanding of the law. That's for sure. I think even when I was a young lawyer, I used to get overwhelmed by, when I went there and I networked and these buzzwords, right? So now I tell my juniors that don't worry, you'll always have people who will come and throw certain buzzwords at you or say, oh, I've networked and everything. Don't get overwhelmed. Be true to yourself. I think that's most important. Do your homework. Make sure you're reading up your knowledge of law. Whatever little that you're doing it well, and that should take care of it.
Ma'am, do you think having a good boss or a good supervisor or somebody you can look up to is very important in the field of law when you actually start working? Especially in cases when maybe the pay is not that good, but you have somebody, a senior who's very good and who's helping you out. How would that pan out?
Definitely. I think not only as a young lawyer, at every step of the way, to have, I'm seeing it firsthand, okay? To have a good boss, to have a mentor. So seek people out, even if it's not your immediate reporting person. There will be someone in the organization. Even if not someone in the organization, someone who's in the same field, who can guide you. And I think that's very important, to have someone with more experience, because there's no alternate to having experience, right? You can read as much as you want, you can talk to people as much as you want, but someone who's gone through the same thing as you, that is invaluable to have someone like that on your side.
Ma'am, if you could give one piece of brutal advice to the young lawyers who are entering or have entered the practice of labor and employment, what would it be?
Interesting question. One piece.
Brutally honest advice.
Set your expectations right. Okay. Don't come thinking this is a very easy practice area, or that it's a very it's a practice area where there's a quick fix to everything. It can get very arduous. Like I said, it's research based. You need to be able to think critically. You need to read between the lines. You need to interpret the law. You need to read the law, the commentaries, and spend a lot of time on it. So come with the right mindset.
That's a great
That
advice.
would be, yes, because I see a lot of people thinking that it's one of the easier practice areas to tackle, and then they are surprised when the work begins. Coupled with the technical aspects, it requires a lot of EQ.
Yes.
Right. So that's what. Prepare yourself and come with the right thought as to why you want to join this practice.
On that note, ma'am, what foundational knowledge do you expect interns to have, especially because now we have the new codes as well?
One is, we are very much aware that which year you study labor laws in. So, say you've not studied it when you're coming in for internship. We of course understand that. But at the same time, what we are looking for is diligence, right? From the students, from the interns. And to that extent, if you know you're joining the labor and employment practice, for example, to do your own background reading. There's information available on fingertips, right? So to understand the basics or to know currently what is happening, right? These are some of the expectations, maybe not the nuances, maybe not necessarily the grey areas, and maybe not even solutions, right? But at least we want to see the diligence that yes, somebody has read up the law, they have working knowledge of what it is, and they also know their current affair, which means they know currently what is happening in this field of law that they want to join.
So should they be aware of the labor codes and to what depth? Yes.
No, of course, I think everyone should be aware of the labor codes. Just like they should be aware of, say, the DPDP Act. Because at the end of the day, we are lawyers. We can't restrict ourselves to just our practice area, right? So at least we should know what's happening in the legal field.
Yes.
Okay. Yes, if you're joining the labor and employment practice or you want to intern in that, instead of knowing just an overview, maybe look up the labor codes, see how they read some critical articles, which talk about the difference between the old and the new regime. We at CAM, we have done a lot of publications on the labor codes, right? So whatever material you get your hands on, of course your source has to be correct. But do a bit of in-depth reading, at least know what are the top 5 aspects or the top 10 aspects or important aspects of the labor codes.
And then what makes certain interns stand out from the rest when you assess them or evaluate them?
See, knowledge, definitely, right? There's no taking that away. Some other aspects we look at it from the lens of trainability. Right? So we see whether, say, basic common sense or their uptake. So if something is being explained to them, how quickly can they absorb it? How quickly can they understand it? And honestly, if you've done your background reading, you will do well in these cases, right? Because you have your background in place. Apart from that, we look a lot at the softer aspects. Softer, but those, frankly, would be more important. Are they taking initiative? Are they genuinely interested in work or not? Are they a team player? How do they do their research? We don't want someone coming in and doing a Google research. Are they going back to the basics of research, which is first opening the Bare Act and reading it, then from there reading the commentary, then doing your case law research. So these are some of the aspects that kind of make an intern stand out.
That's a well balanced answer. Ma'am, picking up from what you just said, what is more important when it comes to assessing the work of juniors and interns? Is it hard work or should it be smart work?
It has to be a mix of both. Again, there's no taking away hard work. You have to put in effort.
Right.
The focus has to be on making yourself a good lawyer. Right. To that extent, there's hard work is a given. Smart work is also necessary. And smartness, in which area of it are you applying? That's very important. Smartness does not mean I do a quick fix research and give a quick answer that okay, I've given it a record time and it's done. No, smartness is knowing that let me take my time, but let me come up with a good answer which is backed by, say, precedents or law, and I can explain why my analysis is what it is. Okay, so you have to be smart. You need to use that smartness in the right way. Smartness also lies in knowing that there's no alternate to hard work. Right?
That's very true.
So yeah, you need to balance it out, definitely.
Right. Ma'am, this is my final question and certainly a very important one. So if tomorrow the labour codes were amended again, what is one change you would actually advocate for? Because you are someone who's actually seeing the practice of labour codes in the day-to-day life.
And I hope it's not amended again because we are just getting to pin it down and know it very well. But I would say that changes to ensure that companies which have presence in more than one state, it is made easier for them. For example, if you see the payment of statutory bonus chapters under the labour codes, the threshold for employees, the wage threshold, who it will be applicable to, state governments are free to decide that. Okay. Now imagine if I'm an employer, if I'm a company having operations in different states, so I have to track each state differently and calculate it differently, which may lead to an administrative nightmare, right? So don't fix those things to the extent possible. Also, the other aspect that comes to mind is the entire concept of core activity. Okay. Yeah, to some extent, I mean the definition is there, but some more clarification on that, on how the exceptions will play out, that will be helpful. I mean, we are taking an interpretation on that, but if it could be codified into the law itself, I think that will give the industry more comfort.
That is a very smart answer. Thank you so much, ma'am, for your time here. We loved this conversation, and we end this episode right here. Thank you so much.
Thank you for having me.